Welcome back to the deep dive.
Great to be here.
Our mission, as always, is pretty straightforward. We take really dense stuff, complex laws, technical papers, you name it.
The kind of material that's crucial, but maybe not the easiest weekend reading.
Exactly. And we break it all down. We want to make it accessible, understandable, really get to the core knowledge.
We're aiming to be that shortcut for you, the learner, to get comprehensively informed on important topics.
And today, oh boy, we are wading into some serious legal territory. Chapter 16 of the Penal Code.
Indeed. This chapter is, well, it's fundamental to understanding modern privacy and preparatory crimes. It covers everything from, like, physical lockpicks to digital wiretaps.
So our goal today for you listening is to really decode this. We want you to walk away knowing exactly where the legal lines are drawn on things like surveillance, specialized criminal tools, and tracking.
And not just what the law says, but hopefully a bit of the why behind it, the thinking that shapes these rules.
It's practical stuff, really. This isn't just abstract legal theory. It impacts technology, privacy, law enforcement, everything.
It really does.
Yeah.
These laws touch on so many aspects of modern life.
Now, before we dive headfirst into the legal weeds, just a quick reminder, if you find this kind of deep dive valuable, if you appreciate us sorting through the complexities,
Please do hit that subscribe button.
yeah, it genuinely helps us grow the channel, bring you more content like this. Your support means a lot.
And don't forget to check out our official website, too. We'll have links to the actual legal text, any extra resources we mentioned today. It's all there for you.
Okay, so Chapter 16, you mentioned it covers a wide range. Where do we even start?
Well, a good starting point is understanding the type of offenses we're talking about.
Yeah.
Broadly, Chapter 16 deals with what the law calls inchoate offenses.
Inchoate. Okay, fancy legal term. Break that down for us. What does inchoate mean in this context?
It basically means incomplete or preparatory. Think of it as crimes related to getting ready to commit another, usually more serious, crime, or attempting it.
So the law isn't just focused on the final act, like the robbery itself.
Exactly. It's proactive. The idea is that society has an interest in stopping crime before the final harm occurs.
Mm-hmm.
Possessing specialized burglary tools or setting up illegal surveillance.
Uh-huh.
Those actions themselves are deemed harmful or dangerous enough to be criminalized, even if the ultimate intended crime doesn't actually happen.
Got it. So having the tool with the bad intent is already crossing a line?
Precisely. It allows intervention earlier in the process. So within this chapter, we're going to focus on four main areas, kind of four pillars of these preparatory and technological crimes.
Okay, what are they?
First, Section 16.01, criminal instruments. These are the physical tools.
Like actual hardware?
Right. Second, Section 16.02, interception of communications. This is your classic wiretapping, eavesdropping, but updated for digital. Focuses on the content.
The actual conversation.
Yes. Third, Sections 16.03 and 16.04, which deal with tracking data. This is less about the content and more about the who, when, where, metadata, stored emails, that sort of thing.
Okay, the digital footprint.
You could say that. And fourth, Section 16.06, physical tracking devices. Think GPS trackers on cars.
Modern surveillance tech. All right, that gives us a clear roadmap. Let's start with the physical stuff then. Section 16.01, criminal instruments. Okay, Section 16.01, unlawful use of a criminal instrument or mechanical security device. This feels pretty old school, like burglary tools.
It definitely covers that, but the definitions are quite specific. There are essentially two main ways you can commit an offense under this section.
Two flavors of the crime. What's the first one?
The first is possession. It's an offense if you possess a criminal instrument, or what's called a mechanical security device, and crucially, you have the intent to use it to commit some other crime.
Intent is the key word there, right? It's not just having the thing.
Absolutely. The intent transforms an object into a criminal instrument in the eyes of the law for the possession offense. And the penalty is interesting here.
How so?
The law grades the possession offense one category lower than the offense you intended to commit with the tool.
Oh, okay. Give us an example.
Sure. Let's say you possess a specially modified tool, and your intent is to use it to commit a burglary of a habitation, which might be a first-degree felony, depending on the circumstances.
Right.
Under 16.01, the offense of possessing that tool with that intent would be a second-degree felony, one step down.
Why do that? Why not just a set penalty?
It reflects a legal principle called proportionality. The idea is that the preparatory act, while serious, shouldn't typically carry the exact same penalty as the completed crime. It scales the punishment relative to the intended harm.
Makes sense. Keeps the focus on the ultimate crime while still punishing the preparation. Okay, that's possession. What's the second offense under 16.01?
The second one targets the supply side. It covers manufacturing, adapting, selling, installing, or setting up one of these devices.
So the person making or distributing the tools.
Exactly. Here, the offense requires that you act with knowledge of the device's criminal nature, and you have the intent to use it yourself or let someone else use it to commit a crime.
So you need to know it's dodgy and intend for it to be used that way.
Correct. Knowledge plus intent regarding its use. And unlike the possession offense, the penalty here is fixed.
Regardless of what crime it was meant for.
Yes. Manufacturing or supplying these things with the required knowledge and intent is a state jail felony. Period. The legislature decided that enabling crime this way warrants a standard, serious penalty.
Okay, state jail felony for making or selling, scaled penalty for possessing with intent. Now, the definitions must be crucial here. What actually qualifies as a criminal instrument?
It's defined very carefully. It's anything, provided its possession, manufacture, or sale isn't already a crime under some other law that is specially designed, made, or adapted for committing an offense.
Let's unpack specially designed, made, or adapted. That sounds like the core of it.
It is. This is what distinguishes it from just a regular tool that happens to be used in a crime.
Right. So my standard hammer isn't a criminal instrument even if I use it to break a window.
Generally, no, because it wasn't specially designed or adapted for that. But if you took that hammer and, say, modified the claw significantly to make it exceptionally good at prying open specific types of locks or reinforced doors,
The adaptation.
that adaptation specifically for a criminal purpose could push it into the category of a criminal instrument. Or think of something made from scratch, solely for illegal purposes, like a sophisticated lock bypass tool not available commercially.
So it's about the unique modification or the inherently illegal design. Got it. What about the other term, mechanical security device?
This is a more specific category. The law defines it as a device designed or made for use by a locksmith to perform services for a customer who needs legitimate entry to property, a house, a car, whatever.
So locksmith tools, basically, like tension wrenches, pick guns, bump keys.
Those could certainly fall under it. By including this definition, the law makes it clear that even tools with a legitimate professional use can become illegal under 16.01 if possessed by someone who isn't a locksmith acting legitimately, and they have the intent to commit an offense, like burglary.
So it closes a loophole. You can't just say, oh, this is a standard locksmith tool if you're caught climbing through someone's window with it.
Precisely. The combination of the specialized tool and the criminal intent triggers the offense, regardless of whether the tool could have a legitimate use in other hands. It focuses on the user's intent in that moment.
Okay, we've covered the physical tools. Now we move into the digital and auditory realm with section 16.02, unlawful interception, use, or disclosure of wire, oral, or electronic communications. This sounds like the big one for privacy.
It absolutely is. This section is really the cornerstone of legal protections for private conversations, whether they're spoken, sent over wires, or exist as digital data.
And the penalty reflects that seriousness, right?
Definitely. Unlike the state jail felony or the scaled penalty for criminal instruments, a violation under this section, 16.02, is generally a felony of the second degree.
Wow, okay. Second-degree felony. That's significant jail time. So what specific actions trigger that? You mentioned interception, use, and disclosure.
Right. The law outlines 4 main prohibited actions. Let's break them down.
Go for it.
First, the most obvious one. Intentionally intercepting, or even just trying to intercept, any wire, oral, or electronic communication.
So the act of listening in or capturing the data stream itself.
Correct. Second, intentionally disclose the contents, or trying to disclose them, if you know or have reason to know that the communication was intercepted illegally.
So you don't have to be the eavesdropper. If you spread the illegally obtained info, you're also on the hook.
Exactly. Knowledge or even just reason to know it was dirty is enough. The third is very similar. Intentionally using the contents or trying to use them, again, if you know or are reckless about whether it was obtained illegally.
Reckless. That seems like a lower bar than knowing.
It is. It means you didn't have concrete knowledge, perhaps, but you consciously disregarded a substantial risk that the information was illegally intercepted. Think of receiving a suspicious recording and using it anyway without checking its origin. That recklessness can be enough.
That really broadens the liability. Okay, what's the fourth prohibited action?
The fourth deals with the physical act of setting up, knowingly or intentionally affecting a covert entry, basically, sneaking into a place for the purpose of illegal interception, planting the bug.
Breaking into wiretap. Got it. So intercepting, disclosing, using, or breaking in to set up. All potential second-degree felonies. That's a wide net.
It's meant to be. Privacy of communication is considered fundamental. But, like you hinted earlier, not every single transmission is protected.
Right. The readily accessible radio exception. This sounds technical.
It is, and it's important. The law says it's not illegal to intercept certain radio communications that are considered readily accessible to the general public. Think maybe some unencrypted walkie-talkie chatter or basic radio scanner stuff.
Okay, but the law must define what isn't readily accessible, right, to make clear what is protected.
Precisely. The statute spends more time defining what is not readily accessible, meaning interception is illegal and falls under the felony charge.
Let's hear that list. This seems key.
Okay, so a radio communication is protected, not readily accessible, if it meets any of these conditions.
Hit me.
1. It's scrambled or encrypted. Simple enough. If you take steps to secure it, the law protects it.
Makes sense.
2. It uses modulation techniques with parameters withheld to preserve privacy. Think specialized radio signals where you need secret technical info to even tune them in.
Okay, hiding the signal itself.
3. It's carried on a subcarrier or subsidiary signal. These are often hidden signals piggybacking on a main broadcast, used for internal stuff.
Like background data feeds.
Sometimes, yes.
Yeah.
4. It's transmitted over a common carrier system. This is a big one.
Common carrier. Like phone companies, cell providers?
Yeah, exactly. AT&T, Verizon, T-Mobile, etc. Even if they use radio waves for part of the transmission, communications handled by them are generally protected, reinforcing their duty to protect customer privacy. There's a tiny exception carved out for old-school tone-only paging, but otherwise, common carrier traffic is protected.
So intercepting cell calls, data streams from major providers, definitely illegal.
Definitely. 5. It's transmitted on specific frequencies allocated by the FCC under Parts 25, 74, or 94.
Whoa, FCC parts. What are those generally?
Highly specialized stuff. Part 25 deals with satellite communications. Part 94 often covers private microwave links used by businesses or utilities for secure point-to-point communication. Part 74 includes various auxiliary broadcast services. Basically, these protect non-public, often commercial or governmental, radio transmissions.
So tapping into a private corporate satellite feed?
Big
trouble.
Very big trouble. Second-degree felony trouble. And finally, number 6, if the communication is an electronic communication, it's automatically deemed not readily accessible.
So emails, text messages, internet data packets, all fully protected under 16.02.
Correct. That ensures broad protection for digital communications.
Okay, that's a complex web of protection, but surely there are times when interception is allowed. What about defenses?
Absolutely. And the biggest defense, by far, is consent.
Consent! How did that work for regular folks, not law enforcement?
For a person not acting under color of law, meaning just you or me, the rule is generally one-party consent.
One-party consent, meaning?
Meaning you can legally intercept or record a communication if you are a party to that communication.
So I can record my own phone calls?
Yes. Or, alternatively, if one of the other parties in the communication has given you prior consent to intercept it.
Okay, so if my friend says, yeah, record our call, that's also legal.
Correct. But there's a huge caveat here.
Always a catch.
This consent defense evaporates. It doesn't apply if the interception is done for the purpose of committing any unlawful act.
Okay, explain.
So, recording your call with customer service to keep a record, fine. Recording a business negotiation you're part of, fine. But recording a conversation where you're planning a crime with someone, or recording someone to get information you plan to use for blackmail.
Then the consent, even your own participation, doesn't make it legal.
Exactly. The criminal purpose poisons the consent. The law won't let you use the privacy exception to facilitate another crime.
That's a critical distinction. Okay, what about law enforcement? They must have different rules.
They do. They operate under color of law and have specific exceptions beyond just being a party or getting simple consent. The most common is acting under a court order, specifically under Chapter 18A of the Code of Criminal Procedure, which governs wiretaps and similar warrants.
The standard legal wiretap authorization.
Right. But there are other more niche exceptions, too. One is the computer trespasser exception.
Computer trespasser? Like hacking?
Pretty much.
Yeah.
Law enforcement can, under very specific conditions, intercept communications to or from someone illegally accessing a computer system.
What conditions? Sounds tricky.
It is. The owner of the computer system has to consent to the interception. The officer needs to be investigating that specific intrusion, and they need reasonable suspicion that the intercepted comms will be relevant to that hacking investigation. It's designed to target the hacker's traffic specifically.
So they can't just listen to everyone on the network.
No, it's meant to be targeted.
Yeah.
And then there's the most dramatic exception. The immediate life-threatening situation.
The emergency exception, when waiting for a warrant isn't an option.
Exactly. Think active kidnapping, hostage crisis. Interception can be done without a prior court order under 2 scenarios.
Okay.
Scenario 1, a magistrate gives consent beforehand, often difficult in a fast-moving crisis. Scenario 2, no magistrate consent, but an immediate life-threatening situation exists, and the person doing the intercepting is part of a law enforcement unit specially trained for this, and the interception stops immediately when the threat ends.
Specially trained and stop immediately. Those seem like crucial safeguards.
They are the legal guardrails. It's a power granted only in dire emergencies, and it's meant to be temporary and strictly controlled. Any evidence gathered needs to meet those high standards or it gets thrown out.
It's that balance again, immediate safety versus privacy rights.
Always a tension there.
One last thing on 16.02 before we move on. What about the devices themselves? The bugs, the spyware?
Right. There's a related offense covering the manufacturing and advertising of interception devices. This is generally a state jail felony.
So making or selling the tools for illegal eavesdropping.
Yes, it's illegal if you intentionally make, assemble, possess, or sell a device knowing it's primarily designed for non-consensual interception and knowing it's likely to be used unlawfully. Even just advertising such a device for illegal eavesdropping is a crime.
Targeting the supply chain again?
Correct. And there are defenses, of course, for legitimate actors, telecom companies doing their job, government contractors, specifically trained law enforcement units.
Okay, we've spent a lot of time on intercepting the content of communications under 16.02. Now, you said we're shifting to tracking the data around the communication. Sections 16.03 and 16.04.
That's right. We move from the substance of the conversation to the logistics, the metadata. Section 16.03 deals with pen registers and trap and trace devices.
Pen registers, trap and trace, what do those actually do?
Think of it this way. If 16.02 is about reading the letter inside the envelope, 16.03 is about looking at the to and from addresses on the envelope.
Oh, okay.
A pen register captures outgoing signaling information primarily, the phone numbers you dial out. A trap and trace device captures incoming signaling information, the numbers that are calling into your line.
So not the conversation itself, just the numbers involved.
Exactly. The statute prohibits knowingly installing or using these devices to record or decode signals to identify telephone numbers dialed or otherwise transmitted. It's about mapping the communication network, not listening to the content.
And the penalty reflects that difference.
It does. Since the privacy expectation for dialing data is considered lower than for the content of a call, the penalty here is a state jail felony.
Still a felony, but lower than the second degree for content interception.
Correct. It shows the law differentiates between levels of privacy invasion. Metadata is protected, but not quite as fiercely as the content itself.
Makes sense. Are there defenses here too? Who can legally use these?
Yes, similar pattern. Communication common carriers, the phone companies, are generally allowed to use them in the normal course of business, for billing, for network maintenance, protecting their systems, or when assisting law enforcement legally.
So AT&T can track call routing data for their network. That seems necessary.
It is. There's also an exception for regular businesses. An employee can use similar technology as part of providing or maintaining a service.
But there's always a but.
But they generally can't do it on behalf of a law enforcement agency or a private investigator unless it's specifically related to investigating the theft of the company's own services.
So the IT department can monitor network logs for internal security, but they can't just become spies for the police without a proper legal process unless someone is stealing company phone service, for instance.
That's a good way to put it. It maintains a boundary.
Oh.
And of course, the other major defense is having a court order under Chapter 18B of the Code of Criminal Procedure.
Chapter 18B, that's different from the 18A you mentioned for wiretaps.
Yes. Chapter 18B specifically governs court orders for pen registers, trap and trace devices, and other forms of electronic tracking and data access that don't involve intercepting the content of communications. It has slightly different procedures and standards.
Okay, good distinction. That covers tracking the who called who. What about Section 16.04? You mentioned stored communications.
Right. Section 16.04 is unlawful access to stored communications. Think emails sitting in your inbox, voicemails on the server, files in cloud storage, text messages after they've been delivered.
So data at rest, not in transit?
Exactly. This section makes it illegal to obtain, alter, or prevent someone else's authorized access to a wire or electronic communication while it's in electronic storage.
And how does someone commit this offense?
Two main ways defined in the statute. 1. Intentionally obtaining access without authorization to the facility where the communication service is provided. This is your classic external hacker breaking into an email server.
Okay. And the second?
2. Intentionally exceeding the authorization, you do have to access that facility.
Ah, the insider threat.
Precisely. Think of an employee who has legitimate access to certain parts of the company network, but then uses that access to snoop into a colleague's private emails or files they have no business looking at. They had authorization to be on the system, but not in that specific data.
That's a really important distinction. The level of access matters. How is this penalized?
There's a gradient here. The basic offense, just unauthorized access or exceeding authorization, is a Class A misdemeanor.
Okay, still serious, but a misdemeanor.
However, if the access was done to obtain a commercial advantage or private financial gain, or to harm another person, the penalty jumps up significantly.
To what?
It becomes a state jail felony. The law recognizes that accessing stored data out of curiosity is bad, but doing it to steal secrets, commit fraud, or blackmail someone is much worse. The motive elevates the crime.
Motivation matters. And the defense is, who can legally access stored communications?
It comes down to authorization again. The conduct is legal if it was authorized by the provider of the electronic communication service, like Google accessing Gmail data for system maintenance within their terms of service, the user of that service, you accessing your own email, or the addressee or intended recipient of the communication.
So if the email was sent to me, I can access it. Makes sense.
Right. Or, as always, if access is authorized by law, specifically citing Chapter 18B again, the court order process for accessing electronic data.
We're nearing the end of Chapter 16. Two more sections. 16.05, dealing with service providers, and 16.06 on physical tracking. Let's tackle 16.05 first. Illegal divulgence of communications by service providers.
Right. This section puts specific obligations on the companies that provide electronic communication services to the public, your ISPs, email providers, etc.
What's the core rule for them?
They commit an offense if they knowingly divulge the contents of a communication while it's in transmission or storage on their system to anyone other than the sender or intended recipient. They have a duty of confidentiality.
But surely they have to divulge things sometimes, for technical reasons or legal ones.
Absolutely. The law provides clear defenses. Divulgence is okay if it's authorized by either state or federal laws, done as a necessary part of rendering the service or protecting their rights property, like routing the message, or, crucially, if they divulge it to a law enforcement agency because the contents reasonably appear to relate to a crime.
Ah, the mandatory reporting idea. If they see evidence of a crime in the data they handle, they can report it.
Yes. It allows them to cooperate with law enforcement when they stumble upon illegal activity.
Now, you mentioned before that the penalties under this section get really specific based on the type of communication.
They do. This is where encryption and the nature of the service really matter for the penalty. If the illegally divulged communication was a scrambled or encrypted radio communication, it's a state jail felony.
Okay, protecting secure signals even if the provider messes up.
Right. But if the communication was not scrambled or encrypted and the divulgence was done for a tortious or illegal purpose or to gain a benefit,
so malicious intent behind disclosing an unsecured communication.
then the penalty drops. If it wasn't a specific type of mobile radio or paging service, it's a Class A misdemeanor.
And if it was one of those old school public mobile radio or paging services,
Then it drops even further, down to a Class C misdemeanor, basically the lowest level offense.
wow. So the law is essentially saying if you maliciously disclose something that was broadcast relatively openly using older, insecure tech, the penalty is minimal.
It reflects the much lower expectation of privacy inherent in those older, unsecured radio transmission types. The penalty scales with the expected security of the medium.
Fascinating how the law adapts, or maybe hasn't fully adapted to different tech levels. Okay, last section. 16.06, unlawful installation of tracking device. GPS trackers on cars.
This is exactly what it covers. It addresses that common modern concern. The law defines an electronic or mechanical tracking device. Very broadly, basically anything that emits a signal to track the location of a person or object.
And the specific crime.
It's knowingly installing one of these devices on a motor vehicle owned or leased by someone else without their permission.
Why specifically motor vehicles? Why not tracking someone's phone or backpack?
That's a good question. While other forms of stalking or harassment might cover tracking a phone, this law focuses on vehicles because they represent a significant zone of privacy and autonomy related to movement. Tracking a car maps someone's entire life: home, work, doctor visits, associations. The legislature singled out vehicles for specific protection here.
Okay, so putting a GPS tracker on someone else's car without permission, what's the penalty?
It's a Class A misdemeanor.
Class A misdemeanor. And the defenses. When can you legally put a tracker on someone else's car?
3 main affirmative defenses. First, and most importantly, consent. If you get the effective consent of the owner or lessee of the vehicle before you install the device, you're clear.
Consent from the owner lessee. Okay.
Second, if you're assisting someone you reasonably believe to be a peace officer acting under lawful authority, like a court order for tracking, you're helping law enforcement.
Makes sense. And the third involves private investigators.
Yes, licensed private investigators have a specific, more rigorous defense. They can install a device, but they need written consent from the owner or lessee of the vehicle.
Written consent. That's stricter than the effective consent for regular folks.
It is. And there's another layer for PIs. If installing the device requires entering private residential property, like a driveway or garage, they also need written consent from the owner or lessee of that property.
Wow, double written consent needed for PIs if it involves private property. That's quite specific.
It adds accountability for a profession that routinely deals with surveillance. And naturally, the law explicitly exempts peace officers themselves when they are installing devices as part of an investigation or with a court order. They don't need consent under those circumstances. Hashtag tag outro.
Okay, that brings us through the entirety of Chapter 16. We went from physical crowbars adapted for crime all the way to GPS trackers and hacking stored emails. Quite a journey.
It really covers the spectrum, from traditional preparatory crimes to very modern technological ones.
So key takeaways for you, the listener. What stands out? I noticed the consistent difference in penalties between messing with content versus messing with metadata.
Absolutely. Intercepting the actual substance of a communication, Section 16.02, carries that heavy second-degree felony penalty, reflecting the highest expectation of privacy.
Whereas collecting dialing information, 16.03's pen registers, or unauthorized access to stored data, 16.04, tends towards state jail felonies or misdemeanors unless there's that added malicious intent like financial gain.
Precisely. The law values the content most highly. Another major theme, as we saw again and again, is consent.
Yeah, consent seemed to be the magic T in almost every section.
It really is. Whether it's recording a call, accessing stored files, or putting a tracker on a car, having the valid consent of a legally authorized party, the owner, the user, a participant, is almost always the factor that makes the action legal instead of illegal.
And understanding who those authorized parties are is crucial. The exceptions for phone companies, law enforcement acting under specific court procedures like Chapters 18A and 18B, and even PIs with their stricter consent rules.
Knowing those boundaries is key to understanding how these laws function in practice.
We also talked about that narrow but critical exception for immediate life-threatening situations under the interception laws, allowing warrantless interception only under extreme duress with strict controls.
Right, that balance between urgent safety needs and privacy rights. Which actually leads to a pretty interesting thought looking forward.
What's that?
Well, the law currently allows that emergency exception based on an immediate, usually physical threat, like the hostage situation we discussed. It requires real-time assessment.
Yeah, makes sense.
But think about advancements in AI and predictive analytics. Imagine algorithms that can scan vast amounts of someone's stored communications, emails, messages, posts over years, and generate a digital profile that predicts with high confidence an imminent threat, maybe a threat of violence or self-harm.
Okay, where are you going with this?
The question becomes, could that algorithmically determined future threat, based on analyzing stored data, ever meet the legal standard of an immediate life-threatening situation? Would lawmakers or courts ever consider allowing warrantless access to stored communications based on such a prediction, similar to how they allow real-time interception for a physical crisis?
Whoa. That's blurring the lines between prediction and immediacy. A digital pre-crime scenario based on stored data access.
It poses a profound challenge to how we define imminent threat in the digital age versus the physical world. Something definitely worth pondering as technology continues to evolve faster than the law often can.
That is definitely food for thought. A fascinating, slightly chilling point to end on. Thank you for guiding us through this incredibly complex legal landscape. It feels much clearer now.
My pleasure. Understanding these rules is vital in our connected world.
And thank you for joining us on the deep dive. We hope this decoding was valuable.
We'll see you next time.